Hello everyone, this is Janvi Gaur with registration number 2139439 pursuing Masters in Data Analytics in Christ University, Bangalore. Today, we are going to talk about the most interesting case of Indian code that changed the rape law in the country, the Mathura rape case. Mathura, a young tribal woman from Maharashtra, was reportedly raped by two uniformed police officers in 1972. Her trauma shook the country and changed the landscape of rape laws in India. The incident took place on 26 March 1972 in Desaiganj, Maharashtra. Mathura, who at the time was between 14 to 16 years old, had developed a relationship with Ashok, a man who was related to her employer. As per customary practice of her tribe, Mathura had eloped with Ashok and was living with him. Mathura was an orphan and lived with her brother Gama prior to this. On the night of incident, Mathura was summoned to the police station regarding an FIR filed by her brother who disapproved of her relationship. After taking the statement of all concerned and asking everyone to leave, two police constables Tukaram and Ganpat asked Mathura to stay back. It is reported that thereafter, Constable Ganpat took Mathura to a toilet situated near the back of building, loosened her underwear and shined a torch over her private parts. He then dragged her to the main building, where he pushed her to the ground and raped her, in spite of stiff resistance on her part. After Ganpat, Constable Tukaram came over Mathura and fondled her private parts. He too tried to rape her, but was unable to do so because he was highly intoxicated at that time. By this time, Mathura's family, who had been waiting outside the police station, started to grow suspicious, since the light of the police station had been turned off and the entrance was bolted from within. They called out to Mathura but received no response, and the noise attracted a crowd near the station. After some time, Mathura emerged from the station and informed the crowd that she had been compelled by the constable Ganpat to undress herself and he had been proceeded to rape her. On hearing this, the agitated crowd threatened to burn down the police station, and the head constable was forced to take down Mathura's statement. Despite the power differential, she decided to take this matter to the court and was able to do so as a young feminist lawyer. Vasudha Damangbar fought the case from 1972 to 1979. The case was first taken to Session Court, which found the defendant not guilty. On appeal, the Bombay High Court set aside the judgment of Sessions Court and sentenced the accused to 1 to 5 years of imprisonment respectively. The High Court judgment held that mere passive or helpless surrender of the body and its resignation to others' lust induced by threats or fear cannot be equated with the desire or will, nor can furnish an answer by the mere fact that the sexual act was not in opposition to such desire or violation. Despite the valid judgment of High Court, which took a more holistic approach to consent, justice for Mathura was elusive. In September 1979, the Supreme Court overturned the judgment and pronounced the defendant not guilty. The Supreme Court's verdict was based on the following three arguments. Mathura did not vocally express her non-consent during the ordeal. There was a lack of piercing on her body. She was habituated to sexual intercourse based on the two-finger test. While the first two portions of judgment became problematic in themselves, it is the third part of the judgment that raised the cause for alarm. To begin with, the two-finger test, which for the longest time was the method for checking whether or not a survivor was in fact raped, is a deeply flawed process. The test is conducted by inserting two fingers inside the vagina to check the elasticity of survivor's vagina and whether the hymen has been ruptured. Going by the number of fingers admitted, the doctor gives his opinion on whether a woman is habituated to sex or not. Secondly, to assume that the hymen can only be ruptured by sexual intercourse is medically incorrect. The test is not only unscientific but also illegal in India. Rally and public meetings. Fourth, Mumbai demanding justice for Mathura and amendments in rape law. But more important than the medical inaccuracy of such tests is to the taboo surrounding premarital sex. The test did not take into account cases of consensual intercourse, and by extension of that, neither did the court. As is clearly demonstrated by this judgment, the presumption was that a woman is to only have sex after marriage, and any woman who chose to have sex before she enters this state sanctioned institution cannot possibly be at the receiving end of crimes such as rape. The court went so far as to say that since Mathura was habituated to sexual intercourse, she perhaps initiated sexual intercourse, seduced the police officer, and then came out and cried rape in an effort to seem victorious in front of her brother and partner. A few days after the verdict was announced, four law professors Upendra Bakshi, Raghunath Kelkar, Lotika Sarkar, and Basudha Damawar wrote an open letter to Supreme Court protesting the concept of consent in the verdict. Important lines from the letter reads, is the taboo against premarital sex so strong as to provide a license to Indian police to rape young girls? Several protests and demonstrations took place in the country following this verdict, and this case is touted to be one of the cornerstones in the development of national feminist movement in India. A number of women's groups were formed as a direct response to the judgment, including Saheli in Delhi, prior to the January 1980 in the formation of first feminist group in India against rape, Forum Against Rape, later renamed Forum Against Oppression of Women. When taking a look at Mathura's case, it becomes important to talk about the power structure to play. Mathura was an orphaned Adivasi teenager who was struggling to make the ends meet. In her first recounting of the incident, Mathura said that the cops had threatened to file a false case and imprison her and her relative if she did not do exactly what they said. Lines from the open letter written to Chief Justice of India best explain the dynamic at the play in the case. Despite the large scale opposition to the verdict in Mathura's case, demanding that it be reopened, the court still held that there was no legal standing in the case of rule in favor of Mathura. Eventually, this led to Government of India to amend the rape laws in our country. In 1983, a new category of was added to criminal laws dealing with the rape. The law mandated that the court presume a woman who says she did not consent to sexual intercourse is telling the truth. Mathura's case also led to in-camera rape trial being conducted as closed proceeding and to ban on identify victims by their real names. Besides defining custodial rape, the amendment shifted the burden of proof from accuser to the accused. It also demanded that before sunrise and after sunset, women cannot be called to the police station. The never seen before protest that rocked India at the time of Mathura rape case were about the tone and tenor in which the Supreme Court spoke about the issue of consent, the manner in which morality and victim blaming was woven into the judgment. Activist Seema Sakhare stands with Mathura left at an anti-rape rally after Indian Supreme Court ruling. Victim blaming and archaic ideas of sexual and morality still form the basis of many judgments being made in our country.